What will disqualify someone from unemployment? Generally, voluntarily quitting from their most recent employer will be disqualifying. Refusing to accept suitable alternative employment is a disqualifying circumstance, but there's some room to argue what suitable alternative employment is. If the employee is otherwise no longer available to work, for example, they've gone back to school in some cases or has some medical issue that prevents them from working, or potentially if it's a position that requires licensure and they've lost that licensure, that might be an example of where they're no longer available to work in suitable employment. There's particular provisions for employees who go out on strike. They're not working, then they're not eligible to get unemployment for 7 weeks at least. But the biggest area of interest for employers is the misconduct question, because employees who are involuntarily terminated for misconduct, as that is defined by the unemployment law, can also be denied unemployment benefits, which would help keep your unemployment costs down. How do employers in New York prove this type of misconduct, which is not necessarily the same as the proof of misconduct under Section 75 of the New York Civil Service Law or anyone else's general understanding of what misconduct is? There are really two things that the unemployment system considers misconduct. One is a situation where the employee had clear prior notice that engaging in a certain behavior would result in their termination. And the other is, even if there wasn't such clear prior notice, the employee's conduct was so bad that it was illegal or clearly unacceptable and likely to result in termination of employment. I generally find the second category to require some relatively extreme behavior in these categories. Most criminal acts are likely to qualify. Then these other categories are probably going to also be criminal acts, but even where there's not necessarily any criminal prosecution, or maybe there's not quite the level of criminal intent that would be necessary under the penal law. But falsifying material documents, consistently falsifying reimbursement submissions or time records, for example, which may also qualify as theft as well. Falsifying whether you cleaned the bathroom like you were supposed to at 2:00 in the afternoon might not alone be sufficiently material to justify a finding of misconduct under the unemployment system. In that sort of case, it would probably be better to put someone on specific notice that you're expected to do this as a condition of your job. And if you don't, both actually clean the restroom and indicate on the schedule that you have done it as you were supposed to, then you are going to lose your job. In which case, if they continue to not do it and you fire them, then you could probably claim and show misconduct. And of course, physically violent behavior in the workplace generally isn't going to be acceptable and often is going to result in the denial of unemployment benefits, even if you haven't specifically already warned the person not to hit their coworkers.